Hey everybody, I saw two new docket updates for the Emani Ellis and Cardi B case. This hopefully will put an end to that saga, but we'll see. We've got two orders we're going to look at. The first is going to be a contempt order. RonRon, attorney Ron A. Rosengenfaza, has officially been sanctioned. And it's only a 6-page order, but we're going to read it in full. And then we will also take a look at the order regarding Emani Ellis's motion for a new trial. It's denied, spoiler alert. She's not getting a new trial. But we're going to look at the judge's reaction to the arguments made by the attorneys for both sides. So let's get started with this contempt order first. 6 pages, we'll get through it pretty quickly. So again, this is in front of Judge Ian Fusselman. So if you guys have missed it, there's been a contempt hearing, request for sanctions. The judge initiated their own sanctions, order to show cause against Ron A. Rosengenfaza. And we've read some of his responses in opposition, saying things like, I'm dealing with hardships right now. I am overwhelmed as an attorney. He gave a bunch of different reasons. And I think the consensus here was overwhelmingly that we didn't think it was going to fly. So what did the court say? So the court, after having provided notice and opportunity to be heard, which they're required to do, regarding the conduct of plaintiff's counsel of record, remember Emani Ellis is the plaintiff here and Cardi B is the defendant, Ron A. Rosengenfaza makes the following findings. So the background. Genfaza represented Emani Ellis in the above entitled matter. Plaintiff contended that Cardi B scratched her cheek during a confrontation. After several continuances, the case was set for trial on August 25th, 2025, with a final conference on July 30th, 2025. Motion in limine re prior bad acts. This is the thing that RonRon kept stepping on over the line for. So there was a motion in limine heard at the time of this final status conference, including a defense motion captioned, they wanted to exclude evidence of alleged prior bad acts by Cardi B. Amongst the various bad acts sought to be excluded was defendant Cardi B's alleged, quote, former association with a gang or gang members during her youth. The motion relied in part on Evidence Code Section 1101A, which precludes the introduction of character evidence to prove conduct on a specific occasion. The motion also relied on Evidence Code Section 350, contending any gang affiliations were not relevant, and Evidence Code Section 352, arguing that any evidence concerning Ms. Almanzar, Cardi B, alleged involvement in gangs or with gang members, lacked probative value and was unduly prejudicial. Plaintiff's opposition provided a review of relevant case law and then argued, without any analysis. In judge lingo, that seems like a little bit of spice here, if you ask me. Without any analysis, the following. Quote, defendant's prior employment history appears to be fair game. There is no reason to hide the fact that defendant was previously an exotic dancer. The rule allows for the admissibility of prior bad acts for other purposes, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. Which I don't know how that would apply to the situation at the heart of this case, but okay. In reply, defendant, Cardi B, noted that plaintiff's opposition ignored controlling legal standards, was conclusory, and failed to offer how the alleged bad acts could conceivably be admissible. Because how does it relate to this incident at the medical office? The court issued the following tentative ruling on the motion. It was granted. This is all the way back before the trial, you guys. Granted, subject to defendant not opening the door. Defendant's prior acts and alleged prior acts, as well as prior involvement in exotic dancing or gang associations, have no apparent probative value, and any references thereto would be unduly prejudicial and likely to confuse the jury and result in an undue waste of time. So, I forget what they call it in California. They're like one of the few states that didn't adopt the federal, numbering system for evidentiary rules. But like in Georgia and like in many other states, we would call that 403 in a lot of the cases that we watch. After being provided with the tentative ruling, Mr. Genfaza asked to be heard by the court. He argued in favor of admitting the evidence relating to defendant's alleged prior associations with gangs. The court explained the rationale behind the ruling and adopted the tentative ruling as the order of the court. So, don't mention this stuff. If you guys watch the trial, you already know what happens, but the judge sums it up here. During the trial, just a little rewind here for the sake of it, the reunion. Mr. Janfaza asked the following question of Cardi B. Question. Do you have any affiliation at this time with a gang? Like, chat, let me know if you think there's any way that you could construe that question in a way that it's not asking about gang affiliation. The court promptly sustained defense's objection to the question and cautioned Mr. Janfaza about the clear violation of the court's ruling on the motion. But then during closing arguments, we have more problems. Prior to closing arguments, Mr. Janfaza requested that the court take judicial notice of certain facts. The pen throwing, I think. After the court ruled, the following dialogue, the court denied the request, and after the court ruled, the following dialogue took place. Mr. Janfaza, I want to be very clear that I intend to argue that in my closing. The court, it's not in evidence, though. After further argument, the court continued. The court, I think it's readily apparent that you can't argue facts that aren't in evidence. And the plaintiff's counsel knows that. I think he knows that he would be violating the rules of professional responsibility by intentionally arguing facts that are outside the evidence that was presented in court. During a later discussion, Mr. Janfaza confirmed his understanding of the scope of closing argument. Janfaza said, I feel that what counsel has just stated is really below the belt and disrespectful to my side. I would never argue the things that are outside of the evidence. Despite the court's clear expression of its expectations, and despite Mr. Janfaza's clear understanding of those expectations, he repeatedly referenced evidence that was not introduced during the trial. The court sustained defense. Oh, this is about the NBA photo date as well. There was do you guys remember this full transcript? There was a weaving argument during this portion, and the court is pulling in the relevant parts. But there was also the issue of Janfaza saying that Cardi B lied about the NBA All-Star Weekend timing. So the court sustained defense counsel's repeated objections, but it did not issue a warning to counsel that further references to evidence not admitted during trial would be subject to a finding of contempt. Then, on September 2nd, 2025, the jury returned a verdict in favor of Cardi B. After the verdict, defense counsel raised the issue of Mr. Janfaza's violation of the in limine ruling and misconduct during plaintiff's closing argument. The court informed the parties that defendant would have 30 days to file a request for an order to show cause re contempt. Defendant filed her application for that order to show cause on October 2nd, 2025. The court issued the order to show cause on October 20th and set the hearing for December 5th. The order to show cause specifically informed Mr. Janfaza of the quasi-criminal nature of the hearing, his rights, and the possible penalties. So the court has to state this because it's required that they do this. So they need to include in their order that they followed these steps. Defendant was ordered to personally serve the order to show cause and related documents on Mr. Janfaza no later than November 4th, 2025. On October 27th, Janfaza, we're going to call him RonRon, filed his objection. On November 5th, Cardi B filed an ex parte application for order reservice of order to show cause, explaining that multiple attempts to serve Janfaza had failed and suggesting that he was intentionally avoiding service. On November 6th, the court granted the application and deemed the order to show cause served, but it also directed defendant to send the order to show cause via overnight delivery with signature confirmation service. On November 18th, defendant filed a declaration with attached a printout of exactly what was asked for, and it was noted that it was refused by recipient. On November 26, 2025, Cardi B filed a reply brief in support of the order to show cause. On December 4th, RonRon Janfaza filed a surreply without leave of court. So a surreply means a reply beyond the ordinary reply, what you're entitled to. And when you do something like that, procedurally, you should ask the court for permission. Hey, can we have permission to file this additional thing? You might see the same type of motion for leave or request if you're going to exceed a word count, if the court implements a word count on specific filings. Hey, we need to exceed this word count. Can we have permission to do that? RonRon just filed without getting that permission. So the court held that, and good point, Martina Nem, he didn't mention previous affiliation, just present. So that's a good one. I think that's a good call there. We've got November 26th, surreply without leave. The court held the hearing on December 5th. The court informed Mr. Janfaza of his right to counsel. Mr. Janfaza stated that he did have an attorney, but that they would not be appearing for the hearing. And then we're also referencing an October 26 declaration from RonRon here with, quote, "I am limited in my ability to provide additional information at this time as I am represented by counsel." Okay. So we can't answer, but we also don't show up with counsel. And this is the court's analysis and findings. So the meat, what's going to happen? Mr. Janfaza's main argument in the pleadings filed with the court in the hearing against the order to show cause are summarized as files. The application for the order to show. So this is a summary of the opposition of RonRon. So RonRon argued, well, the order to show cause wasn't timely filed. 2, I wasn't personally served with the order to show cause. 3, I didn't remember the motion in limine ruling, so therefore I couldn't have intentionally violated the order because I didn't remember it, so no intent. Also, I had been out of town before the trial and my office manager drafted the question outline, and it wasn't my fault that I asked the question. And then also the in limine ruling addressed past involvement in gangs, whereas his question was, do you have any affiliation at this time with a gang? As such, he argues he did not violate the court ruling. So there is exactly what Martina Nem was pointing out. He argued, I'm not an experienced litigator. I had very little sleep and the violations were mistakes and not willful. And also that in previous trials, I made significantly more egregious arguments without facing sanctions. So that's what he argued. The court is not persuaded by these arguments. The application for the order to show cause was timely filed after the court issued its ruling. On the issue of service, the court is guided by the rulings in Cedars-Sinai, where the Court of Appeals found that, in the context of an order to show cause re contempt, due process is afforded when an attorney appears in the courtroom and is confronted with the charges. So he appeared in the courtroom for this hearing, even though he didn't bring an attorney. He also filed an opposition to the order to show cause, a surreply, and appeared at the hearing. So you can't say that you didn't have notice of the opportunity because you responded. The remaining arguments are inconsistent and contradictory. So, I mean, on the one hand, Mr. Janfaza argues he didn't violate the in limine rulings. On the other hand, he claims his violation was unintentional and the result of inexperience. In the context of this case, and specifically looking at the wording of the question concerning gang activity, it is clear that Mr. Janfaza was aware of the in limine ruling and that the question was specifically drafted in an attempt to avoid directly violating the letter, but not the clear intent of the court's ruling. It was no accident. It was not the result of inexperience or stress. It was not the fault of Mr. Janfaza's office manager. It was a knowing and intentional violation of the court's ruling. Moreover, yeah, number 7 was fun. Number 7 was a good time. Moreover, the court refuses to give any weight to the technical variance between the court's ruling excluding reference to prior gang associations and the question regarding any gang affiliation, quote, at this time. The court's order specifically excluded prejudicial character evidence, and Mr. Janfaza still sought to elicit exactly this testimony. They cite here Hawk v. Superior Court, affirming contempt finding against attorney who had no reasonable basis to believe that matter would be relevant or supported by admissible evidence. Even if the violation was not intentional, it is still sanctionable under Code of Civil Procedure Section 177.5 because there was no justification to ask the question. So we've got, let's see, Section 1209A5 states that disobedience of any lawful judgment, order, or process of the court constitutes a contempt of the authority of the court. However, absent particularly egregious behavior, such as here we're giving an example of contempt directed to the trial judge during closing argument that the defendant did not receive a fair trial constituted contempt on its face. And another example that an attorney committed direct contempt by impugning the integrity of the court. A trial court must first warn an attorney of the contemptuous nature of a courtroom conduct before initiating contempt proceedings for a subsequent violation. And here the court sustained the objection relating to Mr. Janfaza's violation, and he did not repeat the conduct. So this is where the judge is like, I'm going to keep it reined in. So I don't believe your opposition here, but at least you didn't keep doing it after you kept doing it once. While the court did sustain objections to Mr. Janfaza's repeated reference to facts that were not admitted during the trial, the court did not issue a specific warning to Mr. Janfaza to stop making further references. As such, the court finds that this record does not support punitive sanctions under Section 1209. So, we're going to get sanctions under this. Here we go. 1209, A5. Oh, no, I mean this one. 177.5. So, even though it's not intentional. So let's see. So it doesn't find that it's punitive under 1209, but under 177.5, that does provide the court with the power to impose reasonable monetary sanctions for any violations of a lawful court order done without cause or substantial justification. So the judge isn't going to go all the way. But here they're going to say the order to show cause included Section 177.5 as one of the grounds for the contempt hearing. Based on the findings above regarding Mr. Janfaza's knowing and intentional violation of the court's in limine order, the court further finds that he acted without good cause or substantial justification in violating this lawful order, and thus imposes sanctions on Mr. Janfaza under 177.5 in the sum of $1,500. So he's got to pay $1,500 in 30 days. And this section, since it does not provide discretion to award reasonable attorney's fees, and because the order to show cause was not based on 128.5, the defendant's request for attorney fees on this issue is denied. So there we go. There we go. And he's got to also give notice. So the clerk of court has to give notice of this order that this attorney has been sanctioned to the California State Bar. Janfaza is reminded of his obligation under the Business and Professions Code to report this order of sanctions to the California State Bar in writing within 30 days. And let's see. What else do we got? And if it was less than $1,000, I guess he wouldn't have to report it for failure to make discovery or monetary sanctions of less than $1,000. So because it's $1,500, he's got to report it. And there you go, just repeating the order that he's got to pay this $1,500 to the court by February 27th, 2026. There you go. There you go. So there is the contempt order, you guys. Next up on the docket is going to be, and let me switch my banner like a good streamer. Let me get more organized here. We've got the order denying Emani Ellis' motion for a new trial. So before we get into that, let's see what you guys are saying. Law Nerd Amber says RonRon is a petulant child in a grown man's skin suit. I mean, I think it's kind of... I can only imagine if it was like a bigger sanction amount, we wouldn't hear the end of this. But maybe this will just be... We'll just go on with it. Hey, Bama girl, good to see you. Good to see you, Miss Sparks. Got everybody coming in here to check out the updates. We've got Miss One, good to see you. Hey, Junior. Hey, GV. Hey, Miss Kels. Hey, Felicia. Angela says this lawyer's the gift that keeps on giving. With the ... lawyer's a bad name. I love that. Good to see Keith. Hope you're staying warm there in Chicago. The weather seems like it's been crazy. Latania's like, I'm over it. Cardi just needs to sue her and the lawyer for real. Like, it's one of those things where, like, don't poke the bear. Don't poke the bear. Cardi B told you. I'll let you go, but I'm warning everybody else. Why keep poking the bear? Why keep poking the bear? Good to see you, Positive QB. Hey, Kimberly. Hey, Annie. Hey, Trikisha. Hey, Factual Live. We've got C. Mish in the building. Danny, Satales, everybody here. Curiously is ready for the RonRon nonsense. And Oracle Cat, my fellow cat, good to see you. Big Baby Jane, good to see you. Hope you're doing well. All right, so we've got E. Capone in the building. Good to see you, E. Capone, fellow Justice Junkie. Good to see you. Hope you are doing well as well. Always get a nice little reunion when we switch topics. Get to see some faces and friends I haven't seen in a while. All right, so this one, let's see. This one's a bit longer. And it's a minute order. And this judge, when he does his minute orders, he like summarizes it and then gets an expansive, he expands on it. So it won't just be a typical minute order where it's like 2 sentences. We've got a little more meat here. All right, so December 5th, we have this this quick little note of appearances. So Ron Jonfaza appeared for Emani Ellis, Peter James Anderson, and Eric Lamb, as well as Liz Moore were there for Cardi B. This was for the contempt hearing and hearing on motion for a new trial. Let's see. We don't need to worry about the contempt stuff. We just covered that. And motion for a new trial. So after reading and considering all moving documents, hearing arguments, and conferring with counsel for plaintiff and counsel for defendant, the court adopts the tentative ruling as order of the court. The court orders as follows. The motion for a new trial filed by Emani Ellis on October 31st is denied. Background, you guys know the background already. And then let's see, on October 31st, 2025, plaintiff filed and served a notice of intention to move for a new trial. The notice seeks a new trial on the following statutory grounds. 1, irregularity of the proceedings. 3, accident or surprise. 6, insufficiency of the evidence. And 7, error in law. And then defendant opposes, and then no reply to the defendant's opposition was filed. So the moving party, that's Emani Ellis here, the plaintiff, argues that irregularities in the proceeding arose warrant a new trial, including purported threats of disciplinary action made by Cardi B's defense counsel to obtain a litigation advantage and a physical encounter between counsel for the parties in the hallway while the trial was still ongoing. So remember, there was an accusation that Cardi B's attorneys threatened Dr. Finke, I think it was the doctor, in the hallway. And we didn't have affidavits, even though it was represented in the argument in the motion that bailiffs and maybe the jury were present. There was no affidavit from a bailiff that said, oh, I witnessed this thing. But it's what was raised in the motion for a new trial. So plaintiff argues that the jury verdict was unsupported by the evidence due to the failure of defendant to disclose Dr. David Finke and Ms. Tiara Malcolm's identities during discovery and their subsequent testimony at trial without plaintiff's opportunity to depose them. Plaintiff also argues that the testimony of these two witnesses should have been excluded. Plaintiff argues that insufficient evidence justified the verdict, as the trial testimony of Dr. Finke and Ms. Malcolm should have been excluded. Plaintiff argued, and it's just such a weird thing to argue insufficient evidence when you're the one that brought the case. Like, I can't get over the logic of making that argument. Plaintiff argues that an error in law warrants a new trial because of the court's denial of plaintiff's request for judicial notice concerning the date of the professional basketball game in relation to a photograph taken by the defendant of her nails. So Cardi B's opposition. Cardi B contended that plaintiff's claims that counsel threatened disciplinary action and made physical contact with plaintiff's counsel are both false and offer no grounds for a new trial. Moreover, the claim that defendant allegedly threw objects at others outside of the courthouse is unsupported by any evidence with respect to purported conduct during the trial and barred by the court's order granting defendant's motion in limine number 1 with respect to any purported conduct prior to the trial. Defendant contends that the court did not err in denying plaintiff's request for judicial notice, as defendant did not, in fact, testify that the photo was taken on the same day as the incident, as the court noted that plaintiff's counsel had misstated defendant's testimony. Defendant contends that plaintiff's claim that the verdict is unsupported by the evidence is also unavailing, as plaintiff oddly argues that insufficient evidence justified the verdict, as the testimony of Ms. Malcolm and Dr. Finke should have been excluded. However, this testimony was properly allowed by the court, given the information reasonably available to defendant at the time defendant's discovery responses were served, and given plaintiff's knowledge of their identities before trial and purportedly throughout the litigation. So remember, the issue was the argument that Emani Ellis didn't know who these witnesses were, didn't have opportunity to find out and do some research on them and try to contact them before trial. But they're people that worked at the same building that Emani Ellis worked at. Like, and they were on the witness list, but as undisclosed witnesses for Emani Ellis. So Cardi B had to go find out who they were. Like, So even if this testimony should have been excluded, the remaining evidence overwhelmingly justified the verdict. And then no reply was filed by Emani Ellis. So the legal standard. The court has the power to vacate these decisions. We're going to skip the legal standard here. Let's see. Discussion. So plaintiff seeks a new trial on the following grounds. We heard the grounds already. However, as the ground of accident or surprise is not addressed or argued in the motion, the court finds no basis for a new trial on this ground and will thus consider the remaining grounds in turn. So basically, they listed this as a bullet item, but then didn't even like do a paragraph, a section addressing addressing this issue. So we're not going to look at that one. In setting forth the grounds for her motion, the court also noted that plaintiff stated that her motion is made upon the minutes of the court and as to paragraphs 1, 2, 3, and 4 above. However, when the application is made for a cause mentioned in the first, second, third, and fourth subdivisions of 657, it must be made upon affidavits. Otherwise, it must be made on minutes of the court. Accordingly, plaintiff's stated reliance on the minutes with respect to issue 1, irregularity of the proceedings, and issue, they're saying 3, accident or surprise, is improper. So, yeah. Irregularities in the proceedings. So addressing this first, issue number 1, plaintiff argues that various irregularities took place during trial. In a motion for a new trial, the court must vacate the verdict if the alleged misconduct materially affects the substantial rights of the moving party. The Court of Appeal has stated, when the trial court has acted and granted a new trial, we must presume that the trial court did consider the whole record and decided that it had committed prejudicial error, and unless an inspection of the record convinces us that it is otherwise, we will not disturb the order. So we're not going to do this all willy-nilly. The willy-nilly standard. When a motion for a new trial is based on irregularities in the proceedings, it must be made upon affidavits. And because new trial motions are creatures of statute, and procedural steps for making and determining such a motion are mandatory and must be strictly followed. Yeah, it must be strictly followed. To grant a new trial based on attorney misconduct, the moving party must show it was prejudicial. To determine if the misconduct is prejudicial, courts consider the following factors: the nature and seriousness of the misconduct, the general atmosphere, including the judge's control of the trial, 3, the likelihood of actual prejudice on the jury, and 4, the efficacy of objections or admonitions under all the circumstances. And remember, the directionality of this is, it's Emani Ellis saying this issue was caused by Cardi B's team, Cardi B's counsel. So even though we just read a contempt order, the contempt order was addressing, the court sustaining objections against attorney RonRon SANCTIONED, counsel for the plaintiff. So it's kind of weird to consider this issue when this issue is being raised by RonRon himself. Well, Emani Ellis. However, a claim of attorney misconduct will not be considered on appeal unless the record shows a timely and proper objection and a request that the jury be admonished. This is a quote, one of the primary purposes of admonition at the beginning of an improper course of argument is to avoid repetition of the remarks and thus obviate the necessity of a new trial, except perhaps in cases of highly emotional or inflammatory language or reference to extremely prejudicial circumstances not in evidence. A jury must be deemed capable, if so instructed, of ignoring references to a litigant's personal or corporate virtues and confining itself to the merits of the case. And we also have, we emphasize again that the particular language used by counsel and the form or lack of objection by defendant in this case are not, this is a quote, this isn't from this case, are not meant to serve as invariable guidelines for future reference. Each case must ultimately rest upon a court's view of the overall record, taking into account the 4 factors. So defense counsel's statements regarding disciplinary charges. Emani Ellis argues that defense counsel Peter Anderson's conduct provided grounds for a new trial because the record establishes that defense counsel threatened plaintiff's counsel to obtain an advantage in a civil matter both before and during the trial, lastly on August 27, 2025 in the Alhambra Courthouse. These threats purportedly included the filing of a report with the State Bar of California regarding plaintiff's counsel's conduct. Well, now his conduct's being reported to the by the court clerk. The court clerk and RonRon himself have to file notice of the contempt order we just read to the State Bar. So isn't it interesting reading these two things back to back? These conclusory facts also identically appear in the supporting declaration of plaintiff's counsel, Ron A. Rosen Janfaza. So remember I was griping with the argument and then the affidavit being a word for word of the argument? I like that the judge wrote this because I feel validated. These conclusory facts are also identically appear in the supporting declaration of plaintiff's counsel, RonRon. Defendants contend that plaintiff's counsel's accusations are baseless and proven false by the August 4th, 2025 letter sent to plaintiff's counsel in response to a threatened press conference on the eve of trial and informing counsel that holding this press conference would violate Rule of Professional Conduct 3.6. So remember, we didn't get to see what this threat was until Cardi B's attorneys filed a response in opposition. They supply the material that Emani Ellis was alleging contained these threats to her counsel. But they didn't just provide the copy of the alleged threatening email. Cardi B's team had to supply it. And it was like, hey, just so you know, if you're going to say, if you don't do this, I'm going to do a press conference on the steps of the courthouse, that would be a violation of the rules of professional conduct. And that was supposedly the threatening conduct of Cardi B's counsel. So the judge says here, after reviewing the declaration of plaintiff's counsel, RonRon, the court finds that the conclusory averments found in this declaration do not provide sufficient evidence of this misconduct by defense counsel Peter Anderson. There is no evidence suggesting that he violated any court orders or rules of professional conduct before or during the trial, nor has plaintiff provided any evidence in the record or other evidence establishing the occurrence of these, quote, several, and several's in quotes, incidents of improper threats. Given the lack of any factual details regarding the threats, including the date, method, and substance of each communicated threat, plaintiff fails to provide an evidentiary basis for determining that these threats were in fact made, that the threats prejudiced defendant, and that a timely and proper objection was raised by plaintiff's counsel in each instant when a threat was made. As a result, the court finds no basis for vacating the verdict due to these unevidenced threats in the record. Thus, the motion is denied as to this issue. So we've got defense counsel's hallway interaction with plaintiff's counsel. Plaintiff argues that defense counsel, quote, also physically intervened when plaintiff's counsel was speaking with Dr. Finke on August 27, 2025 at the Alhambra courthouse, which amounted to an assault and battery. And that, unfortunately, the jury was present in the hallway waiting to enter the courtroom during this interaction. That's quoted from RonRon's motion. In identical fashion, plaintiff's counsel avers to the occurrence of this interaction and the presence of the jury when it occurred. Defendant contends that these accusations are also false and cites to the declaration filed by her counsel, Peter Anderson, in support of defendant's response to plaintiff's application for the order to show cause as an evidence of this falsehood. In reviewing plaintiff's counsel's declaration, so Peter's declaration, the court similarly finds that the conclusory averment found in this declaration do not provide sufficient evidence of this misconduct or the jury's purported presence during its occurrence. So, Ron just said the jury was present. The motion just said that the motion and then the attached affidavit. It was another instance of this copy-paste. Affidavit says the same thing that's in the motion. But there's nothing supplied by Emani Ellis or RonRon, like, hey, here's proof that a juror was there. Here's the bailiff. Here's what the bailiff said. The bailiff has their own affidavit they want to submit. Or we bring the bailiff, we ask the bailiff to speak at the hearing that we had for this issue. None of that. Nothing was presented. So there's just not sufficient evidence presented by the plaintiff to support this claim here. Though counsel attests that this incident took place on August 27th during the trial, there is no evidence before the court to suggest this, quote, assault and battery took place as described by plaintiff's counsel. Now, you are representing your client in an assault and battery case. Like, not criminally, but civil still. And then you're also creating a side story within trial, after the context of the trial, alleging a separate incident, physical altercation. It's just, there's just a little bit of irony here. And you just present no evidence. There's just something that echoes the underlying trial itself. Nor does this declaration set forth any facts establishing that this purported interaction was timely and properly raised by plaintiff's counsel as an issue. Moreover, given the serious nature of these accusations of assault and battery, the court finds it difficult to believe that such an incident could have occurred in the absence of any objection by him that day, or any report by jury members or court personnel who would have observed it. Accordingly, the court finds no basis for vacating the verdict due to this unevidenced hallway interaction and its unsubstantiated prejudicial effect. This is a big ol' nope. Thus, the motion is denied as to this conduct. So let's see what's the court's reaction to the next issue, the pen throwing. Defendant's conduct outside the courtroom. Plaintiff argues that a mistrial is warranted because defendant purportedly threw a pen at another individual outside the Alhambra courthouse on September 2nd, 2025, during a lunch break for the trial. Due to this purported incident, plaintiff argues that additional time is needed. I forgot about this. Additional time is needed to determine if defendant's actions of throwing a pen at a man outside the Alhambra courthouse were witnessed by the jury, and asserts that, quote, jurors would be intimidated if they had viewed this type of conduct. And again, you're claiming that Cardi B, in this case, Emani Ellis' claims were that Cardi B attacked her without basis. So how would the prejudice of seeing Cardi B throw an object at somebody be bad for your client? I just will never understand that argument. I'm not going to understand it. But anyway, here we have these arguments and assertions were also found in the supporting declaration of plaintiff's counsel. Defendant contends that these statements by plaintiff's counsel are inadmissible, 2 words, hearsay, inadmissible hearsay, and that counsel's statements regarding whether this incident was perceived by any of the jurors are merely speculative. In reviewing the averments by plaintiff's counsel, the court finds insufficient evidence to establish the occurrence of this purported incident outside of the courthouse, and that this incident was viewed by members of the jury. Even if plaintiff had provided sufficient evidence of these asserted facts, the court finds unpersuasive the speculation that defendant's purported action of throwing a pen could have, quote, intimidated the jurors into finding, and it's bolded in italicized, against plaintiff, given the nature of plaintiff's claims. Say it, judge, because it doesn't make sense. Let's read it again. Even if there was sufficient evidence of these asserted facts, the court finds it unpersuasive the speculation that defendant's purported action of throwing a pen could have intimidated the jurors into finding against Emani Ellis, given the nature of Emani Ellis's claims. While plaintiff did not provide a transcript of the proceedings addressing this issue, the court does recall that plaintiff's counsel argued to the court that it was necessary to inform the jury of the interaction, and it's bolded, was necessary, and offered to play the video for the jury even though evidence was closed and the jury was already deliberating. It is difficult to reconcile how plaintiff can now argue that a new trial should be granted because a juror may have been present during this incident, when plaintiff originally argued that the entire jury should be shown a video of the incident. I bet the judge had fun writing this part. Like, what are we doing? What are we doing? And Bailey says, if I'm a juror, I'm not ruling the other way just because I might get clipped by a bicky. So, yeah, you could be the next plaintiff. So why not? It's fine. So thus the motion is denied as to this issue. And then we've got insufficiency of the evidence. In deciding whether to grant a new trial based on insufficiency of the evidence, the court has the power to disbelieve witnesses, reweigh the evidence, and draw reasonable inferences therefrom contrary to those of the trier of fact. But the court cannot grant a motion for a new trial based on the insufficiency of the evidence unless, after weighing the evidence, the court is convinced from the entire record, including reasonable inferences therefrom, that the court or jury clearly should have reached a different verdict or a conclusion. And then they got a lot of case law here that insufficiency of the evidence in this context means an absence of evidence, or that the evidence received in the individual judgment of the trial judge is lacking in probative force to establish the proposition of fact to which it addressed. The court does not disregard the verdict or decide what result should have been reached if the case had been tried without a jury as a bench trial, but instead it should consider the proper weight to be accorded to the evidence and then decide whether or not, in its opinion, there is sufficient credible evidence to support the verdict. So could a jury get there under the standard? Although plaintiff argues that the jury verdict was unsupported by the evidence, the basis for seeking a new trial under this ground does not appear to be insufficient evidence in the record to justify the verdict, but the court's decision to allow Dr. David Finke and his employee, Ms. Tiara Malcolm, to testify at trial as defense witnesses. So it's not, the court error of allowing this testimony. Somehow they're couching the error of allowing this testimony is evidence, to be introduced as being insufficient evidence. Doesn't compute. At the outset, it is apparent from the court's review of the evidence as a whole that this case is not one of those rare occasions where the jury's verdict is so at odds with any reasonable view of the evidence. So there's no way he's buying this. To the extent that plaintiff misrelies, I've never heard that word, misrelies. Have you? Misrelies. To the extent that plaintiff misrelies on this ground for relief in challenging the court's decision to allow the testimony of these witnesses, the court finds plaintiff's argument as to this testimony unavailing. Specifically, plaintiff testified that there were third-party witnesses to the incident. Because plaintiff was employed at the building as a security guard, plaintiff may have been the best position to either know the names of these witnesses, or at the very least, to be able to determine their names. Plaintiff does not complain, nor is there any evidence that defendant did anything to prevent plaintiff from undertaking efforts to identify them. Further, during the final status conference, it was apparent that ongoing efforts were still being made to identify and locate the witnesses for trial. In addition, during the trial, when the court did rule that these witnesses could testify, the court also allowed plaintiff to call her own additional witnesses who had just been identified, although she later elected not to. Given these circumstances, plaintiff fails to establish a factual or legal basis for the exclusion of these witnesses at trial, and her reliance on Thoren v. Johnson and Washer as a case on point, in quotes, is misguided. As plaintiff solely relies on the presence of this testimony as the basis for seeking a new trial under the statutory ground, and as this testimony was properly allowed, in weighing all of the evidence, the court finds the sufficient credible evidence supported the jury's verdict. Therefore, the motion is denied with respect to this ground. And then error in law. So, let's see. Let's get to the court's analysis. Plaintiff argues that the court erred in denying her request for judicial notice as to the date of the 67th National Basketball Association's All-Star Game. And Pro Bowl's tonight, right? Isn't the Pro Bowl tonight? I think, right? Tuesday? Yeah. So, just thinking of, the, football equivalent of the NBA All-Star Game. I think that's tonight. I could be wrong. I don't know my dates and times. Defendant untruthfully testified that a picture that she took during that time occurred on the same date as this game. However, plaintiff failed to provide a transcript of the trial testimony on this issue. As such, the court must rely on its own recollection of the proceedings. As was noted by the court when discussing the request for judicial notice during the trial, it was the court's recollection that the substance of defendant's uncontradicted testimony was that she had her nails done before her trip to Los Angeles for the All-Star Game, and that the photograph she was shown depicted her nails as they were during her week-long stay. As such, and I'm proud, this is a guy judge, he's getting it, you get your nails done, it's they can last for at least a week. I like that he conceptualizes this, he gets it. As such, the specific date of when the photograph was taken during that week was immaterial. Accordingly, the court properly denied plaintiff's request given the date's apparent lack of relevance to any issues in the action. To the extent that the court's recollection of the testimony was incorrect, plaintiff's failure to provide the transcript of the proceedings as part of this motion precludes the court from finding that the date of the NBA All-Star Game was relevant, or that the failure to take judicial notice of that date could have affected the result of the trial. So, if you're tuning in late, if you missed it, if you couldn't make an inference from any of the paragraphs we read, Ellis's request for a new trial was denied, and everybody's been presented with this ruling in open court. And let's see. Counsel Peter Anderson is sworn to testify about the courts. So this already took place. This is just the orders finally released. But in between this tentative ruling and now that it's published, counsel for Cardi B was supposed to testify on sanctionable costs, and he testified, and I have not seen an order on that quite yet. So After reading and considering all moving documents, hearing arguments, and conferring with counsel for plaintiff and counsel for defendant, the court takes the matter under submission. This is from December 5th, so that's old. So there we go. Finally have the court adopting its tentative ruling. We got to see what it was. And I just saw this hit the docket, but it was filed on January 29th. So there we go, you guys. There we go. We are caught up. Sheriff Chuck says, I hear the judge saying, silly boy, in his response. Kerno Audits, good to see you. Miss you, Kerno. Guys, we are in 10 minutes. We are looking at day 2 of the Edric Faust case. If you missed Georgia trials, if you like cold case trials, if you like things like the Christopher Wolfenbarger trial, if you want to see an annoying prosecutor, it's apparently the district attorney is like lead prosecutor trying this case. It's weird. But he's really annoying. And so far, I think the defense attorney, Ahmad Cruz, it's Crews, really, really great. We've only had 2 witnesses, short witnesses, but very, very good questions. Great opening statement, maybe a little bit long, but laying out that this case that's being brought against his client like 25 years later is only DNA evidence, and it may have been a consensual encounter, but rape shield laws are making it tricky for him to argue that that's an explanation of why his client's DNA could have been found on an oral swab. And it's just a hot mess to watch. So if you're interested in messy trials and what I think is very good lawyering so far from what I've seen from the defense attorney, we're back in Georgia this week watching that trial. It's going to be day 2. All you missed was opening statements, but you can get right into it. This is going to redirect over there, and it should be right in the live section on my channel wall if you want to come join us after the fact. But I think it's crazy. Totally recommending it for you. I'm all in. Yeah, that was the lowdown right there, Kerno. Martina knows as I was catching up on it, but then you went live. My bad. I saw these updates, and I was like, oh boy, what happened with RonRon? So... And then Angela Thompson says, we all know why she was hiding, this is back to Emani Ellis, why she was hiding all those witnesses. She should have helped her, but they saw the incident and knew the truth that she was the aggressor. Yeah, so you don't want to put someone like that on the stand. So, yeah, we are starting the day with sanctions and fines here in this case, but yesterday the defense attorney, he had to pay $1,000 to the court this morning, because he crossed the line according to the judge, even though I don't know how to characterize it, but if you watch the arguments, the district attorney making the arguments to the court, he's like, this happened, this happened, this happened. And then the thing that would be the issue, him saying something that would get into the victim's sexual history, which would be a rape shield law issue. He couldn't recall what was actually said. And the court reporter couldn't find what the judge wanted to hear read back. But the judge said, I found that you made this specific statement that nobody could recall with specificity deliberately, and it's a violation of the orders of this court. If you want to talk about something like that, you need to at least give the court notice. And it's bizarre because the state's opening statement, they went first, went on and on and on about how the victim's boyfriend, maybe they had been broken up at the time, is kind of unclear. But the state's representing it as boyfriend at the time, that they were fine. The murder happened on a January 19th. But the prosecutor's like, you know, he gave her a nice Christmas gift, and he was supposed to spend that Saturday with her for her 24th birthday. The date of everything happening was January 19th, a Friday. And it was fine. Everything was dandy. No issues there. No issues there. He's great. He works hard. He wastes his gas money for his job. He has an alibi, but it's just the word of a friend. And they didn't talk to him. They warned his parents that police were going to be looking at their son right when they found Tara's house set on fire and she was dead. But then the police didn't go talk to him and start interrogating or interviewing him right away. He also had all these marks on his hands. And to me, it kind of looks like, you know, everybody has like little fuzzy hair on their hands. it looks like there's parts of his hands, there's a lot of hair here, but then there's no hair in this area. And part of the crime, it's alleged that the perpetrator took a chenille blanket, lit it on the stove by putting it on the electric burners so it would catch fire, and then carried it into the bedroom where Tara was, and then put it on the bed to set the bed on fire. So, I don't know, that kind of seems really sus. But the state is vouching for this guy. And then in the defense's opening statement, they were objecting, and the judge was getting annoyed at a simple reference by the defense that, hey, it's possible that my client and the victim could have encountered each other at a Mexican restaurant that night. Oh, objection. So it's like, it feels like the defendant can't raise a defense. It's a really high energy case. It's probably going to piss me off. It's great lawyering from the defense so far. I'm getting agitated by the prosecution. So again, I think it has all of the elements. If you guys like the YSL trial, if you guys like the Christopher Wolfenbarger trial, I think it's one of those. So yeah. So I got to it, Sheriff Chuck. It took me a minute, but I got there. And then Laundered Amber says, wasn't he just stating the burden of proof lays with the state? That's what I took from it. That's what I took from it too. I agree. Like they have to explain to you this, or they can't rule out this. But I don't know. So this is going to redirect. We start in 4 minutes over there. Good to see everybody if you're just here for the Cardi B updates. If there is anything more that happens with this case, in the words of Brian Steele, God forbid, we'll get to it. Also scrolling up, seeing some people I missed. Good to see you, Paula. Other people's drama. We got Matt in the building. I got T-Way. Also got Mrs. K Grift. I'm loving life. Good to see you guys. KP. Always good to see KP. We've got, Sabata says no hat. I'll put it on for the next stream. And who's paying for this nonsense? Isn't Ellis just incurring more and more costs for this? I am not sure if she'd be paying for these like billable hours. And for the contempt issue, that's not really on Emani Ellis's shoulders anyway. It would just be the motion for the new trial. But I don't know. I feel like this might have been like out of pocket for RonRon. I guess in 2 ways. So yeah, there we go, you guys. I also want to say hey to Kelly Bean. Thanks for joining us today. Thank you for hanging out. Casually Kiki in the building as well. And we've got Law and Order New York City. We might be missing some Law and Order over in Athens Clark. We're about to head next for this Georgia trial. But good to see everybody, you guys. Take care. See you in a little bit. 2 minutes now. And everybody have a good one.